law from the enforcement standpoint. Distinguished magistrates and participants, you'll be aware that the SADC Parliamentary Forum is the only interparliamentary organization within the SADC institutional family. The forum, therefore, covers a territory of over 250 million inhabitants and touches the lives of individuals in countries which are of low income, middle income countries in the region. The forum has quickly come to the realization that gender-based violence is a social phenomenon that transcends all walks of life. Gender-based violence affects the lives of the wealthy and fortunate, as well as the downtrodden and those who are struck by poverty and many other ills. Gender-based violence affects women more than men. It affects children. It also affects every age, every person of every age, irrespective of the color of the skin, of one's political inclination. It is no secret, honorable magistrates, that GBV can potentially occur in the household or at work alike. In addition, the gender-based violence scenery is an ever-changing one, with gender-based violence taking forms and facets that become more creative day by day. For instance, cyber stalking or cyberbullying are now increasingly becoming a form of gender-based violence, when this was unheard of a few years ago. In addition, gender-based violence in the form of imposition of economic hardship has also become increasingly common. You will certainly appreciate that gender-based violence laws are inadequate in most of our SADC member states, and that in most cases, gender-based violence is likely to go unpunished, if not completely unnoticed. Honorable magistrates, GBV is now all pervasive and is insidiously creeping into the lives of SADC citizens. Today, as we speak, there are certain anti-gender-based violence policies in place and certain gender-based violence laws that operate. However, they fail to be fit for purpose. The SADC model law on gender-based violence is thus designed to remodel legislative thinking and to provide useful benchmarks for the guidance of legislatures. Honorable magistrates, in this vein, I wish to add that the SADC model law on gender-based violence is a natural outcome that emanates from the strategic plan developed by SADC parliaments in 2019 and comes to an end in 2023. In this strategic plan, it is inferred that the forum needs to advance a culture of human rights, including the right to physical integrity and health, and that in so doing, model laws that are prepared at the level of the region will have to not only be human rights compliant, but also justiciable and enforceable. Without the potential justiciability of a law, courts of justice will not be able to apply legal provisions to stop or punish GBV. Therefore, the strategic plan of the forum has preempted that issues such as GBV that intersperse with human rights have to be justiciable and enforceable in the courts. We also believe that enforceability should transcend to courts and tribunals, including the magistrate courts at national level. Since we are speaking here of a regional platform, I would like to say a few words on how the regional initiative of the SADC model on GBV fits within the broader SADC region. It's hand in glove with the SADC regional strategy or framework of action that has been developed by the executive. However, as you are aware, the regional strategy is limited, pardon me, the regional strategy is focused in ensuring that legislative provisions outlawing negative traditional social and economic political practices are in place. Honorable magistrates, this August gathering will have to work together with the SADC Parliamentary Forum in ensuring that when magistrates are involved in adjudicating for GBV offenses, they take on board the wealth of research that this model law has put together in ensuring that protection of our citizens is paramount. I would also like to underline the fact that this is a soft law and will not usurp the powers of our countries insofar as transplanting this model law for it to be domesticated. We lose this soft law for persuasiveness, in particular, international and regional instruments for which the SADC model law has been inspired upon. Distinguished magistrates and stakeholders, this consultation is fundamental, and I'd like for you to open up and assist us in ensuring that we meet our goal today. On this note, I wish to reiterate my gratitude for your attendance today, and I wish you a pleasant session.
Thank you very much, Madam Secretary General, for your incisive remarks, as always, on point in characterizing the nature of the model law, that it must be it's human rights compliant, and that a soft law can be useful without necessarily displacing the national laws in our countries. So thank you once again for those incisive opening remarks. The next speaker, my dear friend and sister, Shanaz Mia, a colleague I have worked with in the area of justice and human rights for the longest time. She is a judge of the High Court of South Africa. I think she's based in Johannesburg. And I thank her more particularly because when I approached her, I gave her the shortest possible time because we were working on a tight schedule. And when I sampled my friends of ability who I could approach with the little chances of refusal, if there are no compelling grounds, she was one of those who came to mind. And she didn't turn me away by saying, "How can you come to me so late?" She was willing to roll, and I think it was mainly on account of her passion for human rights and the role of law in effecting justice and for the welfare of the people. So thank you very much, Justice Mia. It's now my pleasure to call upon you to give us your keynote address. Justice Mia.
Thank you, Justice Dingake. Thank you for the invitation to address you, and all protocol is observed. Yes, I do have a passion for gender-based violence, and I willingly agree because I did work in the Magistrates Court at some point, and I did sit in the family court. So I can speak to the topic. So to start off, this issue of gender-based violence is not something new. We have 7,000 years of recorded civilization where women have been experiencing indignities. And indignities is a soft word, as I would borrow from Madam Sekoma. Gender-based violence is the term that we use, and gender-based violence is committed against women who make up 51% of the population in most countries. This violence is related to the power imbalances between the genders. According to sociologists and archaeologists, and it results in the oppression and the devaluation of women. It also finds support in various purported religious and customary practices that are not intended to oppress women, but in reality, they do so upon examination. And this will be evident when my brother, Justice Dingake, offers his presentation of the model law later, but I will make some reference to one or two aspects today. Now, over the years, women have been debased continuously. This problem has drawn attention in the last few decades, and this is so, and rightly so, because it impacts on women's dignity, it impacts on their right to equality, it impacts on their rights to be secure, their rights to freedom, their rights to self-determination and independence. In South Africa, these rights are protected by our constitution. And similarly, in the SADC region, there are laws in the land which protect these rights. And I believe that this is the reason why in the SADC region, we believe that it is necessary to address this issue, recognizing that we do have the highest rate of violence against women and girls, where we see news daily that women suffer violence, which range from simple assaults to sexual assaults, rape, incest, sexual harassment, which can occur at work, at school. Trafficking in women and children has been on the increase and occurs in insidious forms. And with our borders becoming porous, or our borders becoming open, it has become a lot easier for trafficking in women to occur. This has become a breeding ground for domestic violence. It also results in rape and even murder. We have not seen as many cases, reported cases of murder as we have seen in the last few years. And the associated negative consequences that these have for women and upon women's psyche and upon the psyches of their families and on society. We need to recognize that gender-based violence is a violation of the person's human rights, this being the woman in this case, and that these are rights that are protected in terms of international human rights laws, such as the Declaration of Human Rights. amongst others. I will not refer to all of them, but my favorite one is the Convention on the Elimination of All Forms of Discrimination Against Women. So the basis of proceeding recognizes that men and women are equal and enjoy equal rights and freedoms. And the international treaties support the status of women who enjoy these equal rights of freedom and independence, the same that men do. So the insults, the assaults, and the abuse that women have endured have reached such proportions, so much so that it has become the topic of numerous studies, and it weighs heavily upon our collective psyche as a society. It impacts on productivity, and it impacts on our well-being as a society. Thus, this has resulted in the recognition that this insult upon women, because of the loss of life, the harm, the impact of society, and because of our recognition of the international instruments, and it's calling for countries to legislate to ensure that there are proactive measures. It calls for us to legislate in our individual countries. These assaults have been upon our mothers, our grandmothers, our aunts, our sisters, our daughters, our stepdaughters, and sometimes upon ourselves. And I wonder if there's a person on this platform today that is not able to say, me too, who does not have a person who by some degree has not been affected by some form of violence, in any form of violence. If there is such a person, you would be privileged today. And whilst abuse has existed for centuries, today we are entrusted with a responsibility to eliminate the social evil. So having empowered ourselves with the knowledge, we are responsible for ensuring that the legislation is implemented well. We may think that the laws are soft, but soft laws can do hard work. So countries having implemented legislation seeking to address the abuse of women and children, we eradicate numerous instances of assault, domestic violence, sexual assault, rape, trafficking, femicide, murder. Well, look at their own laws and compare to the model law, where countries have realized tremendous success in legislating around preventing gender-based violence. It's essential to share this information. So this forum does well in seeking to introduce this role model law so that countries may share information in order to share best practices and to take back what works, what does not work, in order to inform the countries of origin so as to amend existing legislation or in terms of drafting general legislation. When I've had regard to the general requirements, it appears that it seeks to tackle the issue successfully. And I've compared it to our own Domestic Violence Act. And today, my brothers and sisters in the judiciary, magistrates, are invited to consider this model law. When confronting this issue, several procedural provisions have been suggested. And the first one, which makes provision for the victim to have speedy access to assistance and to be treated fairly and justly when accessing services, is a basic right which a victim ought to have. Abuse can be, is, and often is debilitating for a victim of abuse. And when such a person comes forward, they often do so after enduring long periods of violence. It is thus essential that such a person is treated compassionately upon arrival. Hence, the need for speedy assistance and for empathy and compassion. Waiting in long queues, either at the police station or at the administrative support section at the magistrate's court, does not assist a victim who has been abused and is often traumatized. So waiting in long queues whilst having taken time off work is challenging and often dissuades a victim from seeking relief. A lack of empathy from an assistant or an administrative assistant or a law enforcement officer at the police station or prosecutor or even a judicial officer who is considering an application once the application has been processed. Is a factor which may cause an applicant to turn away. And I say this because I have seen applicants coming into court and being told to come back a day or two later because magistrates are not available. You are asking an abuser, you are asking a victim to go back to the perpetrator, to go back to the place of danger when the model law makes provision for them to be received with compassion and empathy. A further aspect that is important is the issue of confidentiality. We acknowledge that women and children are mostly affected herein. So it is not unusual that the model law would suggest that women be permitted to request a female police officer. But I would extend that, and I would suggest that where a woman is coming to a court and requests to see a female clerk, that be made available and that a female interpreter be made available to assist her in order to ensure that she's able to divulge sufficient information. And the reason for doing so is that enough information needs to be captured in the statement in order for the magistrate to consider the application fully. In an instance where an application is brought before the court. I've had an opportunity to have an occasion to consider an application where an application is placed before a magistrate at the time where the perpetrator had followed the victim to church, threatened the victim with a firearm, was arrested, and was in custody in the holding cells, waiting for a first appearance. At that point, the perpetrator's application came to court. But what appeared from the application was that that was not the first time that the victim had come to court. The victim had come to court 2 times previously, and the application was refused on both previous occasions. What did it take in order for the application to be granted? Was it an instance where there wasn't enough information? And was it because the victim did not feel that there was sufficient compassion? Was it an instance of interpretation? Because it was a foreign national, and there is a lack of foreign interpreters.
Judge,
Yes.
we have an issue with connection. Some cannot hear you properly. Some of the participants cannot hear you properly.
Do you want me to
Apologies,
speak
yes.
louder?
No. I think there must be something wrong with the particular participant because IT is trying to work on it. Are we all not able to hear Justice, Mia?
I can hear her. I can hear her clearly.
We can hear her. I can hear her from Tanzania here.
Yes, I believe that the connection is because IT has been working on it. I've been trying to communicate with them. So I believe that Honorable Nyambuli Tanguraja could kindly look at what's happening with your connection on that end, maybe your volume. And then I hear Jackie Wessels also. Oh, Jackie Wessels advising that maybe try and reconnect. That's why I didn't interrupt. I realized it was an individual's program. Apologies for that.
Okay. Shall I wait for Judge Sabuni to connect? Oh,
I think
we can proceed.
yes.
So was it an issue with interpretation? Or was it an issue with the application being dealt with by a male clerk? Or was it an issue that there was not sufficient information being given? But it took 3 applications and the victim being threatened with a firearm and being arrested by the police before a protection order could be granted. This reflects the importance of ensuring that we maintain the victim's dignity, because that right is guaranteed. It's guaranteed in our Constitution, and that right is guaranteed in many constitutions in the region. It is equally crucial that sensitive information is often revealed, which necessitates that we are alive to the sensitivity of the information when protection orders are considered. What I also am alive to is the absolute necessity of an on-site counselor at the point that a victim comes in. When a traumatized victim comes in for a protection order, it is necessary for debriefing at that point. It is advisable to debrief the victim and then to refer the victim on to appropriate further counseling. We cannot continue to underestimate the damage that the abuse inflicts upon the person's psyche and mental well-being. The counseling and support work that goes towards the victim gaining their sense of self and regaining their power and the power imbalance that has led to the abuse is important in ending gender-based violence. And what we need to be alive to is that domestic violence cannot be mediated. So this sensitivity and compassion and the willingness to listen are essential. And a second area where the sensitivity is important is in the area, in the criminal arena, where a victim does not necessarily come for protection order, but goes through to report either sexual assault or rape or a previous bodily assault. It is important that statements are gathered in a timeliest manner. And I cannot stress the number of times that dockets have been postponed for further investigation. This impacts on the victim's sense of trust in the justice system. And this is an issue that needs to be addressed with law enforcement. But as judicial officers, magistrates can play a role. They can play a role in determining how long and holding law enforcement officers to account, and ensuring that seniors play a role in ensuring that statements are gathered in a timeliest manner. And this is what the model law suggests as well. That this chain of evidence, which requires analysis of the scene, the victim's evidence, should be completed quickly and without delay. And where a victim does not have bruises, we are not able to read the emotional abuses and the emotional scars that a victim carries by the threat of intimidation. With regard to victim-centered and age-appropriate interview rooms, it is important that we have regard to the victim's age, and where appropriate, it is important to ensure that when we are dealing with young victims, that an intermediary is available in order to assist the victim to give evidence, and the evidence is tendered via video linkage. Now that we have moved to the age of the virtual platforms, this possibility of giving evidence through an alternative form and not necessarily in person has become more realistic and a greater reality. We were limited to video linkages. Now, with the internet and with virtual platforms, the victim does not need it appears that the victim does not need to come to the court. This then makes provision, as provided in the model law, for the staggering of interviews and the staggering of attendance. It means, in effect then, that the prosecutor could interview the victim on one day, and the victim could testify from a virtual, remotely, from another venue, and virtually, whilst the perpetrator comes into the court building. It ensures the safety of the victim, and the perpetrator is at court. It also has cost implications in that it becomes an inexpensive manner because there are no witness fees. However, when there are children, it is important that a parent participate and that the parent is a parent who is a non-offending parent. Where a victim elects to give evidence or elects not to give evidence and the proceedings progress in the absence of the victim, it is important that the victim is kept abreast of those proceedings. I've already addressed the issue of police officers and investigation reports. I'll move on now to the option of court orders. What would be appropriate for court orders? We have to be creative in terms of the orders. The role, the requirement is that the victim's rights need to be protected. So the order needs to include an order for personal protection, and this may often include restraining the perpetrator from remaining in the home. Yet, we find that there's a reluctance to do so because often the perpetrator may be the owner of the home. And we forget that in countries where community of property is the norm, that these are joint owners of the property. And unless the parties have contracted out of the community of property, the victim owns half of the property, is an equal owner of the property. Once again, the issue of equality comes in because we attribute less value to the victim. Often, the perpetrator will be the breadwinner or will be bringing in the greater portion of the income. So the assumption is that he is the breadwinner, he earns more, and he cannot be ousted from his home. What is lost sight of is the importance of protecting the rights of the victim. So we're balancing the rights of the victim, and the order requires that the perpetrator be removed or restrained. Now, the perpetrator could possibly find alternative accommodation, but because he is half the owner of the property, there's a reluctance to grant those orders. And we lose sight of the fact that the contribution of the victim in the home is devalued, and we attribute more value to the cash portion. And in doing so, we further devalue women. There needs to be a recognition that we need to attribute more value to women's work in the home in order to elevate women's positions as well. There should not be a reluctance to restrain perpetrators from entering the home. It's essential to recognize that this should be applied without fear, because the law provides for such protection. Moreover, depriving a victim of the protection provided by the law when requested and there are grounds for such relief denies the victim of a right that she is entitled to. This is the issue where I think the customary or religious right comes in. The modern law makes provision for a victim to be relieved of performing matrimonial services and rendering conjugal rights if ordered by a court. Now, I understand that matrimonial service may well be the cleaning of the home, and conjugal services, we all understand what that means. In doing so, I think that the model law is revolutionary. I think that it is something that must be upheld. And I think that we should be supporting that. Women must be able to say no. And we must support women in saying no. I do not want to do that. And I say no. And a woman's no must be respected. When it comes to the issue of programs, I think what we have overlooked is the issue of sending perpetrators to various programs, and specifically anger management programs, rehabilitation programs. Whilst there is provision for programs, I think specifically looking at the cause of violence, we need to recognize that violence is learned behavior, it's poor management, emotional control, and that needs to be unlearned. And that takes practice and it takes time. But one needs to start somewhere, and the perpetrators need assistance in that regard. And that comes in by way of attending programs and ongoing support. And the requirement may be that they need to attend programs for a particular period of time. What I do like about the law is the provision for alternative places of safety for victims. We have failed. We have failed women in that regard. In terms of places of safety, women often come to court, apply for a protection order, and go back home, come back and withdraw the protection order because they have no place to go to. And because we are not able to support them. In that regard, I think that whilst Madam Pekoma has suggested that it is a soft law, I think that we can actually apply the law so that it is effective and it hits quite hard so that it knocks the ball out of the court and we can eradicate gender-based violence successfully with the remedies that have been suggested and that my brother will be addressing, with the orders and with the injunctions and the requirements. When taken together, I have no doubt that if we applied those, we would realize success. The only aspect that Madam Sokhoma has brought to my attention is the reason why we need to engage is because we need to have uniformity in our region so that our laws mirror each other. Because we rely on each other for precedent a lot of the time. And in closing, I would like to thank you for this opportunity. I look forward to the engagement herein. Thank you. Justice
Thank you.
Naloke.
Thank you, my sister, for your very elaborate exposition of the importance of this model law. And coming as you do from the ranks of the magistracy, it became apparent that we had left the realm of theory and have now, we are now deep into the practical world, because most of the examples you spoke of were real life examples. They were, so that is why, because of that unique exposition from that angle, I was prepared to let you speak for as long as you want, because I found there was so much value in what you said. And from all indications, the Secretary General was not going to allow me to stop you. So thank you so much. I will not do any justice by attempting to summarize what you said, other than to say that I think you spoke about practicalities that we need to observe, but more particularly about the place of victim in our criminal justice system. and that at every stage of our criminal justice system, we need to exhibit empathy, compassion, and commitment to ensure that justice, the wheels of justice roll out faster, but that we are victim-centered in our approach. Indeed, the entire gender-based, this model law is victim-centered. So thank you so much. I tried to write as much notes as I can, because every second of what you said had some value. And I can't thank you more than this. Thank you, Mia. Much appreciated. Now, we will not have someone to share experiences with us around personal experience on GBV, much as we would have liked to. So this means that I must now invite the next speaker, and it's my singular pleasure and honor to call upon Linda, Ms. Naidu, National Project Officer for Gender-Based Violence, the United Nations Office on Drugs and Crime, Regional Office for South Africa, to present the background papers in the time allocated so that we can have some time to go through the model law. Linda, it's my pleasure to call you to the virtual platform. This is your time.
Thank you so much, Program Director. Can you see my presentation?
Yes.
Perfect. So good morning, colleagues, Your Excellency, Honorable Magistrates, Madam Secretary General, esteemed Madam Mia, distinguished ladies and gentlemen. I stand on the current protocol. I'm just going to make sure that I am I want to strengthen my presentation. Just not able to do that, to take it to a presenter's view for some reason.
The slideshow, Linda?
Yeah, unfortunately, my screen is being blocked by a whole lot of other icons, unfortunately. Will this do, Judge? Will this be okay if I just continue in this mode?
Yes.
Okay, perfect. Thank you for that. So to actually provide a brief overview of my presentation, I am going to inform you about the context of gender-based violence and its forms. And I think that Madam Mia and Madam Secretary General has done justice to this area. So I'll just briefly provide an overview. And I will also provide some statistics from the global and regional context, also focusing on the impact of gender-based violence and the reporting of such, but also giving you a bird's eye view of the legislative frameworks for international human rights framework, African human rights framework, the legislative strengths of member states, the gaps in legislation in the SADC arena, but also those implications of gaps for gender-based violence. I'm sorry, I'm just trying to, maybe if I actually hide my view, it'll actually work better perhaps. No. No, I'm just not able to actually win with my technology today. Sorry about this. Nope. Okay, I'm just going to take it off the screen. Okay. Gosh, it's not showing well on my side at all. Okay, so Judge, just give me a moment. I'm going to stop sharing and start and try sharing again. Maybe that will help.
All right.
Okay, I think I've got it. Okay, so violence that occurs in trying to understand and unravel gender-based violence, it's violence that occurs as a result of the normative role expectations associated sorry. Again, I'm having these problems. It's as a result of the normative role expectations associated with a person, as well as the unequal power relationships between the genders within a specific community. And with regards to gender-based violence, we get a number of forms that actually, that include gender-based violence. And we commonly look at physical, economic, sexual, psychological, structural abuse within an unequal economy. And these particular forms manifest in various forms, in rape, sexual harassment, trafficking, sexual exploitation, harmful cultural practices, but also importantly during this period of COVID, we've also seen an extensive increase in cyber violence. It's an area and phenomenon that existed before COVID, but during this particular period with the excessive use of the internet, we've seen an increase in cyber violence. We also see gender-based violence manifest in the form of femicide, which involves the killing of a female person or perceived female person. And violence as a result of sexual orientation is also a huge phenomenon. And violence as a result of one's gender identity and expression and sex characteristics is also another well-known manifestation. State violence, in which women and girls are denied access to sexual and reproductive health care, is also a major concern. So in understanding the concept of gender-based violence, we need to take cognizance, and Madam SG's mentioned that gender-based violence disproportionately affects women and girls. And this occurs in different contexts, whether it's public or private, in the home environment, the work situation, the school environment. And it takes place in a variety of different forms of relationships, during peace times, but also in conflict situations. And it affects women throughout their life, whether at birth, but also, at the latter stage of their life, during the late stages of one's life. And we see that gender-based violence is exacerbated by cultural, economic, ideological, technological, political, social, and environmental factors. And regardless of what form gender-based violence exists, it results in tremendous harm, tremendous suffering, because, and then also we find that the perpetrator in most situations threatens the victim and deprives them of their freedom and their rights. So gender-based violence is enabled by the prevalence of gender inequality and is rooted in patriarchal gender and social norms. We also find that it is prevailed by economic injustices, poverty, education, and alcohol abuse. There's sufficient research to say there's a correlation between gender-based violence and alcohol abuse. When we look at the statistical prevalence of gender-based violence, we find globally 18% of women experience violence by an intimate partner. And this occurred in 2020. We find that 1 in 3 women have been exposed to violence, but when it comes to intimate partner violence, 18% is the prevalence rate globally. In 2017, globally, 190 million women between 15 and 49 years who wanted access to avoid pregnancy did not use any contraceptives, constituting state gender-based violence. In the SADC region, the major forms of sexual violence in the region include rape, trafficking in persons, and in seven countries, 20% of females between 15 and 24 years reported sexual violence from an intimate partner. And in some countries, gender-based violence exceeds 50%. So sexual violence against adolescents in their early years is also highest in the conflict and post-conflict context. Research that was done by the United Nations Office on Drugs and Crime indicated that in 2017, 87,000 women were killed globally, and 30,000 of these women were killed by their intimate partners. Others were killed in other circumstances, but also most predominantly by family members. In 2017, the highest rate of female victims of homicide by intimate partners was recorded in Africa. And the number of women killed by intimate partners or family members is higher today than what estimated in previous years. So as our previous speakers have indicated, the home is the most dangerous place for a woman. Women continue to be affected by this type of violence to a greater degree than men, which is indicative of an imbalance in power relations between women and men inside the domestic sphere. And when we look at the impact of gender-based violence, we find that violence against children and gender-based violence is closely linked because there are intergenerational cycles that are established with boys who are more likely to continue perpetuating and perpetrating the cycle of violence, and girls more likely to be victims as adults when they have been exposed to childhood exposure of gender-based violence. And costing studies estimate that gender-based violence is extremely costly to a country, not only economically, but socially, and the productivity of a country. Social costs that compromise sexual and reproductive health, mental health, well-being, productivity, mobility, and capacity of survivors to lead healthy lives is compromised largely. And we need to take cognizance of the fact that gender-based violence is traumatic. And this traumatic event multiplies the effects on mental health problems for both women and children. It further inhibits women from decision-making within the household, at work, in the economic sphere, the social context, and also impacting on their participation in public activities and exercising a citizenship. The social and political significance of gender-based violence also include the inaction of society in defending the human rights of women and denying them a public discussion of these crimes. Further, when we look at the current context within COVID-19, we find that crises are never gender neutral, whether it is a conflictual situation, whether it is a context of terrorism, or in COVID-19, women and girls are hurt by the economic and social fallout of most contexts. And this is no exception in the case of COVID-19. The analysis by the United Nations estimated that in 2021, 435 million women will be living on less than $1.9 million per day. This is less than $2. And 47 million women will be in poverty-stricken conditions. COVID-19 has definitely pummeled feminized labor sections because we find that women are predominantly in the informal sector. Last year in 2020, globally, 243 million women and girls were subjected to sexual violence by an intimate partner. And emerging data has shown that violence against women and girls has definitely intensified since the outbreak of COVID-19. And violent partners may use their confinement to further exercise their power and control over women, and women have less income and fewer opportunities for social contact and limited access to community support and criminal justice support, all of which gives them fewer exit options. When we're looking at the issue of reporting by women, we find that globally, less than 40% of women who experience violence report these crimes or get help. And within the SADC region alone, victims generally do not seek legal recourse because of factors such as fear of being blamed for breaking up the family, fear of reprisals, shame about airing their personal affairs in public, but they're also economically dependent on their perpetrator. They also believe that the police or legal agencies will not back them up when they report this particular matter. And we also find that women usually blame themselves for the violence due to cultural and social issues. They internalize social values where they see themselves as being subordinate, and it's actually okay to be that way. They accept cultural norms that regulate a couple's role, their role as a spouse and a mother, and they idealize family and marriage. We find that women, when research was done, say, well, it's okay that he beats me up. It's because he loves me. This is how he shows his love. He stalked me because he's jealous, and this is okay. With regards to the SADC legislative frameworks, we find that the SADC protocol seeks to promote gender equality in the SADC region. And specifically, the protocol requires state parties to enact and enforce legislation prohibiting all forms of gender-based violence and ensuring that perpetrators of gender-based violence, including domestic violence, rape, femicide, sexual harassment, mutilation, and other forms of gender-based violence are tried by court with a competent jurist. Despite the existence of some GBV sensitive legislation, gender inequality is still widespread and is limited enforcement of the laws. In addition, one of the shortfalls in GBV legislation is the inability or reluctance by government to ensure their commitments, which is evidenced by the ratification of international legal instruments. When we look at the international human rights frameworks, we see this is presented collectively by various international legal instruments and offers a guide on the practices in GBV. The International Human Rights Framework is a system of conventions, treaties, declarations, implementation, committees, but the reporting of how protection is actually ensured in a particular country. The foundation of all of this is the International Bill of Human Rights, comprising the 1948 Universal Declaration, the 1966 International Covenant on Civil and Political Rights, and the 1966 International Social and Cultural Rights. These are all particular documents initiated by the United Nations. The International Bill of Rights is supplemented by human rights treaties. Example, when it comes to the protection of specific vulnerable groups, we have the Convention of the Child. Sustainable Development Goals also provides for the prevention and mitigation of gender-based violence, and we have several SDGs that are important. But of most prevalence for this particular area of work is the Sustainable Development Goal 5, which addresses gender equality, and SDG 16, which looks at the issue of criminal justice. The United Nations General Assembly resolutions on the intensification of efforts to eliminate all forms of violence against women, and the United updated model strategies and practical measures on the elimination of violence against women and girls in the field of crime prevention and criminal justice is exceptionally important as reference documents in the international arena. When we look at the African Human Rights Framework, we see that the African Union's Agenda 2063 identifies gender-based violence as a major obstacle to peace, security, development, which is often fueled by armed conflict, extremism, and intolerance. The protocol to the African Charter on Human and People's Rights, Women in Africa, the Maputo Protocol, brings to the forefront the importance of the elimination of gender-based violence. Also of importance is a SADC strategy on the sexual and reproductive health rights of women. And of recent as well, we have the regional strategy and framework of action for addressing gender-based violence for 2018 to 2030. We have many legislative strengths in the SADC arena. We have 11 SADC member states have laws on gender-based violence, 13 particularly on sexual assault. With the exception of one state, all SADC member states have laws pertaining to harassment laws, sexual harassment. From three member states in 2009, we now find that all SADC member states have laws in this particular arena. So all member states offer some form of services to survivors of gender-based violence. Unfortunately, most of these services are offered by NGOs who are generally poor resourced. So the bulk of this work lies on the shoulders of the NGOs. With regards to gaps in legislation in the SADC region, we find that there are legal frameworks in 12 member states which still do not offer, legislation that protects women against discrimination, which actually, and they are not appropriate definitions and concepts as per reference to CEDAW Article 1. There's also limited provision in the law for legal aid for women facing gender-based violence. And we also find further, in 7 member states, there are gaps in laws covering nationality, statelessness, and internal displacement. We also find that the criminalization of abortion in 13 member states, resulting in unsafe abortions, is also a challenge. In 7 member states, disadvantaged groups of women, lesbian, bisexual, transgender, intersex persons face multiple and intersecting forms of discrimination, hate speech, and stigma that the law has not adequately addressed. We also find that 5 member states do not have labor laws that adequately deal with sexual harassment, and 4 member states have criminalized child marriages, but 12 member states have no or limited legislation around the area of this particular mandate. In 15 member states, we find limited recognition of online sexual abuse exploitation, which offers women and girls poor protection against cyber gender-based violence. We find that with regards to marriage and sexual offences legislation in the SADC region, it's not adequately supporting and protecting women, which ultimately infringes on their rights, example in the situation of polygamy, and is limited consideration to the definition and inclusion of femicide and other gender-related killings. In conclusion, I would like to emphasize, and we've heard it from my two previous speakers, gender-based violence is a violation of human rights, and the law is an important governance process that can ensure that states respect, protect, and promote human rights. Hence, member states are obligated to educate their citizens of the pervasive nature of gender-based violence. In no uncertain terms, violence against women and girls is a regional problem with devastating effects on individuals, family, and society at large. Gender-based violence, especially violence against women and girls, is an obstacle to the achievement of the sustainable development goals and the full realization of women's rights. And women experience a continuum of violence, which often escalates into their killing. Hence, the response that is required has to be a sustained criminal justice response, which is well coordinated, integrated, collaborated within a multi-sectoral approach. Furthermore, states have an international obligation to prevent and investigate and ensure the punishment of offenders who perpetrate violence against women. And states have an obligation to ensure equal access to justice and remedies for victims and survivors. The credibility of a government's response to gender-based violence is important. It's depicted on the strength of its laws, but not only in the prevalence and presence of those laws, but also importantly in how it actually implements and prioritizes gender-based violence in that country. And we see from the presentation that member states in the SADC region have an uneven landscape, whether it is via legislation, policies, implementation, the enforcement of the law is unequal and uneven pressure and implementation to counter gender-based violence. Most of this is primarily due to the fact that legislation in all member states is gender neutral. And when a legislation is gender neutral, it results in the recurring lack of access to essential services for women, resulting in their protection, their recovery, their safety, and resulting in the impunity of offenders at large. So we find there's a lack of accountability, inadequate resourcing of gender-based violence, victim-unfriendly centers, and we also find that there's limitations with regards to research and data is not adequately available. And when data is not adequately available, we find that the incidence of gender-based violence is undocumented and hence unaccounted for. And when we have reliable and credible data, it's a bedrock for policy formulation and programs and resourcing, which actually ultimately helps inform, plan, cost, implement, evaluate, and review our programs and policies on gender-based violence. So colleagues, that's it from me. I thank you for listening and open up for any reflections, but over to you, Program Director. Thank you.
Thank you very much, Linda, for that very elaborate and clear exposition. I think the highlights of your intervention Again, the recurring theme, I think it's important for participants to bear this in mind. The recurring theme is human rights, human rights. So this gender-based violence modern law is really centered on human rights. There are countless instruments, international instruments and regional instruments, SADC protocols, resolutions that you'll find referred to in the model law, and that every speaker has referred to. But one of the things that I think I can highlight from what Linda said is around cyber violence. I think is one aspect sometimes of gender-based violence that we neglect. She refers to that. And also violence as a result of sexual orientation or gender identity. There are big issues in our region in particular that Linda has ably alluded to. And the scary point, scary but obvious point, that the home, believe it or not, is one of the most dangerous places for women and children. And if the home can be a dangerous place for women and children, you can imagine how debilitating that is. And there are many other points that she raised, but I thought I should highlight those, as she also gave the figures and the costs, and spoke about costs, not only financial costs, social costs, economic costs. They are huge. So we are dealing with an issue that is very critical to our region. So let me not waste much time. Thank you, Linda, for that. Thank you very much. And move on to the next item. But before I do so, just to indicate that any comments, any questions arising out of Justice Mia's intervention and that of Ms. Naidu, please park them. You'll see that in the program, we didn't budget separately for plenary after each speaker. There is only one provision for plenary discussions and engagements. That is after I present on the model law. So just park them and bring them on board at the right time after I have spoken. You'll find that they overlap and they will easily gel and connect to each of the speakers that has spoken. Now, I am tempted to do that which I don't like, which I have not done, which I got training for, which from the experience of Linda, maybe particularly be problematic from my side, to share the screen and PowerPoint presentation. I have an abiding dislike for PowerPoint presentation because it tends to take away the concentration on the articulation of the issues and cast them right into the screen. So I'm tempted, also given the time, that I must just give an overview without the distraction of a PowerPoint presentation. Unless there is a strong opposition to that, I'll proceed accordingly. I'm going to give an overview of the model law. We presume, of course, that we try to send, within the limited time, we try to send this model law to participants, but we understand that there may not have been sufficient time to go through the model law and read and understand its provisions. So this presentation that I'm going to make, it does not attempt to present the entire provisions of the model law. Within the time frame given, that is an impossible task. It will take days, if not weeks, to go through each and every provision of the write-up that constitutes the model law. So time does not allow us to do that. So what I will do, I will simply highlight the key elements of the model law, especially those related to your work as the magistracy, and as highlighted in particular by my sister, Mia, so that we zero on that which matters, where we can then get maximally or optimally your views. And this presentation does not follow the numbering of GBV model law. The model law is on its own, it's about 8 parts. Most of these parts are of a general application. For convenience and practical purposes, my presentation is structured as follows, into 3 parts, basically. Part 1 will be what I call preliminaries. Preliminaries in order to contextualize the entire model law, to understand the background and the context. And then that part 1 will be dealing with the model law as a guiding tool, the objectives, the form, and the style, in order to understand, and also talk quickly about the preamble and other preliminary provisions. And then I'll deal with part 2 that deals with the human rights that are implicated by this model law. And lastly, part 3 will squarely deal with issues that are of particular relevance to the magistracy, as I said, what I consider the heart of the presentation. This deals with access to justice, procedural protections. Mia spoke about this at length, about protection orders, ensuring that that we make sure that victims are protected by the orders that we give this order speedily. Those issues, what I consider the heart for purposes of this particular cohort. And the last part, and then I will conclude. So that is the structure I am going to follow. On the form, the gender-based violence model law is structured in the style and form of approved similar SADC model laws that have preceded this current one. This relates to the model law on HIV and the model law on ending child marriages. So they follow that kind of form. So it is hoped that the form should not be anything of concern, as member states are free to adjust the provisions of the model law in a manner that they deem fit. So the style also, the gender-based violence model law is drafted in such a manner that it can easily be used by national drafters to develop and draft law that is germane or context-specific to their own countries. The contents provide just best practice provisions derived from various regional and international legal instruments that you will find reflected in the model law. So that is very important. The objectives of the SADC model law, essentially the key objective is to set standards, to set the principles, to set the measurements that we can hold member states accountable. Those standards and principles and measurements that member states can use, which I have already said accord with international human rights law. And also more critically, to provide for legal rights, secure legal protections, and also secure legal recourse for victims. So that is the objectives of the model law, as I have indicated. The form I've already spoken about the form that it follows previous model laws. The preamble, you will realize it runs into many pages. If you have the model law with you, it runs into many pages. But at the heart, the crux of the preamble is basically to refer to the international and regional legal instruments that have provided the inspiration for this model law. So that is the preamble. For instance, among the very important international legal instruments that it refers to, that I must mention for your future reference as magistrates, in order to understand the model law and also to help you in your work. The first one is the Universal Declaration of Human Rights that the preamble refers to. The second is the Southern African Development Community, SADC, Declaration on Gender and Development of the 8th September 1997. It's a very important instrument. And of course, is the SADC Treaty. And then is the African Agenda 2063 and the African Charter on the Rights and Welfare of the Child. The Maputo Protocol, very critical in shaping the content of this model law together with other instruments that I referred to. And the Convention on the Elimination of All Forms of Discrimination Against Women, otherwise called CEDAW. You remember that Justice Mia mentioned that there are many of these international legal instruments, but she said the one that she prefers most is CEDAW. So it's referred to in the preamble, and to show you that it's part of a whole array of instruments that inspired the SADC model law. And then the Rome Statute of the International Criminal Court, otherwise called the Rome Statute. Those are some of the inspirations to the model law. As the magistracy, you will need to have these because they constitute a very precious source of international law, which you can refer to in your judgments, even before this model law is adopted or domesticated in your countries. You can use these materials referred to in the preamble in order to deal with issues of gender-based violence. Now, with respect to the model law, it is hoped that member states shall undertake a process of legislative reform to give effect to this model law and observe its objectives, and that member states shall enact and enforce national laws prohibiting all forms of gender-based violence that address and punish all forms of such violence in line with international law as provided. The scope. This model law applies to all persons, and this is critical. Scope. The model law applies to all persons without distinction of any kind, such as race, color, sex, age, language, religion, nationality. And you heard Linda speak about the pervasiveness of gender-based violence around issues of sexual orientation, around issues of gender identity. So it applies to those. This model law shall also be construed to apply to the full extent of the definition of gender-based violence and to the offenses established under this model law. It applies to transgender persons, same-sex persons, sex workers, and the rights, benefits, protections, interventions, assistance, and services specified in this law shall also apply and be available to victims. The point that Justice Mia kept on emphasizing. Now, in the event of conflict, the Secretary General mentioned that this is, once adopted, it could be a source of law, soft law. So it goes without saying that given its status, it is not binding on states, but it is persuasive and it can be used where necessary to clear ambiguities and also to provide, to fill in gaps that may be there. Where there are conflicts or inconsistencies between customary, religious, and statutory law shall prevail, and the matter shall be resolved with respect to recourse to human rights, gender equality standards. That is very important to take into account. The GBV model law and extraterritorial jurisdiction of national laws. A member state shall ensure that any law on gender-based violence shall have extraterritorial effect. I pause here because many of you would know that criminal law is confined into the territories of our states generally. But this gender-based violence model law says that when we domesticate it, we must give consideration to making sure that it applies extraterritorially. And Justice Mia spoke earlier about, I'm connecting all these themes because they're interrelated, about porous borders, and spoke about trafficking of women. And you will see then the relevance of this gender-based violence law having extraterritorial effect. And the law shall apply to any offense committed outside the territory of the member state when the offense is committed by a national of another member state, by a stateless person. That is the scope, the application of the gender-based law. You being lawyers, I'm speaking to the magistrates, you would understand that lawyers, judges spend so much time arguing about words, including about where an exclamation is, a comma is, and what that may mean. So this gender-based violence model law, it has a section on interpretation, just like any other statute, where you have, in order to be clear about what you are talking about, you have to have an interpretation section. So we have an interpretation section in this gender-based violence model law. And I won't go through that but it's important for your own guidance. It, for instance, defines domestic violence and says that domestic violence means any action or omission based on gender perpetrated by a family member, underline that, the consequence of which cause or may cause harm or suffering to a woman or child, whether physical, psychological, and again, Justice Mia spoke at length about the psychological harm, sexual, economic, including death, injury, deprivation. That is the whole issue, incest, rape, murder, femicide, that has been spoken about earlier. And it also defines gender as meaning the roles, duties, and responsibilities which are culturally or socially ascribed to women, men, girls, boys, and men. And also defines gender-based violence and gender stereotypes and harmful practices. That includes customary, traditional, religious, or social practices that negatively affect or behavior, attitudes, or rights which threaten or may threaten the health, social welfare, dignity, physical or psychological development of a person. And marital rape is defined. Earlier, I think it was Linda who spoke of the uneven legal landscape in our region. And this uneven legal landscape manifests itself in the legal attitude or the legal system's attitude to marital rape. And you may find that in certain countries, marital rape is an offense. In some other countries, it's not an offense. But this gender-based law being aspirational, and also because it is consistent with international human rights, it does define marital rape and also sexual harassment. That is the preliminary part of this. I am tempted to stop here deliberately with preliminaries for any short and quick intervention before I go to part 2, which will be quick because I'll be dealing with the human rights that have been spoken about that are included in the SADC model law before I go to what I consider the heart, being the access to justice and procedural protections. Any view, any comments?
Yes, Judge.
Yes.
My name is Peter Ganduru. I'm calling from Malawi.
Yes, from the heart, warm heart of Africa.
Warm heart of Africa. Yes, I should thank you very much, Judge, and all the presenters for the brilliant presentation that they have delivered this morning. But I have one question that I wanted perhaps an explanation in terms of the extension of the gender SADC law, when you have hinted that it will have no territorial boundaries. I am speaking this in the context of Malawi, that for Malawi, for any law to be applied in the course of Malawi, it has to be domesticated within Malawi, either by an act of parliament or by any other means. Otherwise, in terms of the hierarchy, any law which is external can only be persuasive.
Yes.
What are we going to do with such kind of conditionalities, if at all? Some countries also have such kind of conditions. Thank you.
Thank you very much. Yes, that is true, actually, because the legal systems that obtain in our respective countries is mainly the predominant legal system, let me put it that way, is the dual legal system. It obtains, I think, in Malawi, it obtains in Botswana, I think Zambia, if I'm not mistaken. I think South Africa to some extent. Some people say that South Africa also has monist features. I'm not sure about that. Mia may speak to it more eloquently than me, but that is a real handicap. It's a handicap. The hope is that the law, the SADC model law, would be domesticated in Malawi. It would be domesticated in all other member states and become part of the national law, and then it can be put into good use. Whether that will happen, I think is a different question, but that is the hope that that will happen. And I'm sure the Office of the Secretary General is working on a long-term program to ensure that at some stage, it should be possible for these laws to be transformed into national laws of member states. Thank you very much, Your Worship, on that. I think I will proceed. Others can just note and pack the questions. Proceed so that we have maybe a plenary at the end. Part 2. Unless there is a burning question from someone before I proceed to part 2. Now, part 2, I think this entire model law has 8 parts, if I'm not mistaken, or thereabout. Part 2 deals with human rights-based approach and policy direction. The rights outlined in this part are a restatement of certain rights that are specified in international legal instruments, and this includes the Universal Declaration of Human Rights and the other declarations that I referred to earlier, if you remember, when I was speaking about the preamble and the instruments that inspired the preamble. So the rights that are protected under this gender-based violence are all inclusive. They are not exclusionary. We may be familiar with jurisdictions that privilege civil and political rights over socio and economic cultural rights. This model law takes a universalistic view of rights and a very broad view of rights that go beyond civil and political rights to include socio-economic and cultural rights. Protection from discrimination is key. It obliges governments to ensure that discrimination does not take place against a victim on grounds of race, color, sex, sexual orientation, and so forth. And that a competent authority, judicial institution, and a service provider shall display at the premises of work information on its non-discrimination policy and practices. Now, of the many rights that are there is no time to go one by one and deal with those rights. But those of moment to us in this particular consultation process are access to justice. The model law says a victim has a right to access justice. A victim has a right to execute judgment against the state after 1 year of the judgment, if no action is taken by the government as provided in the judgment. A judicial institution shall not order any security for costs on matters related to gender-based violence. The government shall ensure that the provisions of this model law are enforced and widely publicized so as to sensitize victims, communities, traditional authorities, and all other stakeholders. And it also speaks of right to fair trial. A victim has a right to a fair trial before a judicial institution and to have a dispute or complaint decided timely. I think is one thing that Justice Mia spoke about, timely, and she of course went beyond that to talk about empathy of judicial officers, to talk about compassion, and all those find expression somewhere in this gender-based violence model law. It says that a law enforcement officer and a judicial institution shall ensure that a trial for a gender-based offense is commenced and judgment given without unreasonable delay. We know as practitioners of the law, as servants of the law, that sometimes issues of delay are resource-based. And this gender-based violence also speaks to the issue of violence in some of its provisions, that you need to enable the judicial officers to ensure that judgments are given without delay. And it also speaks about employers, prohibition against discrimination, as part of the rights that we need to pay attention to. And it also speaks about equality, privacy, dignity, and respect, access to information, protection from harmful practices, the right to education, access to education facilities, the right to health is mentioned in part 2. The right to employment and social security, that falls under socio and economic rights. I said earlier that the model law goes beyond civil and political rights to encompass the socio-economic and cultural rights. It speaks about the right to nationality. A woman has the right to confer her nationality onto her children and spouse on an equal basis with men, and that all children, regardless of their sex, found or born on the territory of a member state, shall acquire the nationality of that state, if stateless, and that a woman has the right to renounce her nationality on the same basis as men. A woman and a girl and her children shall not be deprived of their nationality if stateless. Speaks also about the right to asylum. Every woman has the right to asylum, including the right to asylum due to gender-based violence, including a right to asylum due to gender-based violence, in line with the relevant conventions and principles of international law. The rights of vulnerable women and children are also captured in Part 2. So those are the rights that find expression in Part 2 of the model law. Now I speak to what I now said is the heart of the model law, insofar as the magisterial bench is concerned, because it talks about access to justice and fair treatment. Access to justice and fair treatment. It says that a victim shall be treated with compassion. Justice Mia spoke about that at length. And provided with all support for him or her to regain control, and the government shall ensure that confidentiality and a victim-centered approach shall be respected at all times. And again, Mia spoke to that. A law enforcement officer or an appropriate authority shall ensure that a victim statement is taken promptly. Shall ensure that a victim statement is taken promptly in a professional and non-judgmental manner, and in a manner that is sensitive .
Justice Ngake, can you just unmute, please? Justice Ngake, can you unmute?
I have unmuted, is that fine?
Thank you. Somebody was interrupting.
Okay, should I continue?
Please proceed.
Yes, I was on the law enforcement officer or an appropriate authority shall ensure that a victim statement is taken promptly and in a professional, non-judgmental manner, and in a manner that is sensitive to the situation of the victim, and ensure that a medical legal examination is arranged if appropriate and is done in a timely fashion, gender-sensitive manner that takes into account the unique needs and perspectives of the victim, and respectful manner so as to protect her and her dignity and integrity, and ensure that all available evidence that can lend credibility to the allegation is collected. And this is very important. And ensure, among other things, that the scene is visited in a timely fashion, and the scene is viewed and protected to preserve evidence. If scene viability is confirmed, a thorough crime scene examination should be undertaken, and evidence shall be gathered, stored, processed to meet the chain of evidence requirements. I think earlier Justice Mia spoke about this, about whether there are many other interlocking factors that we deal with in the administration of justice, the quality of evidence, the time when the evidence is gathered, the preservation of evidence, all those are critical to ensuring that justice at the end of the day is done. It speaks about arrangements should be made for a scene and victim evidence analysis, and ensure that when working with victims who are girls, that services are tailored to the unique requirements of the age of the girl, and ensure that interview rooms and interviews are gender and child friendly. They are gender and child friendly, and where necessary or appropriate, ensure anonymity and confidentiality. And that the procedures that we adopt in our courts should be child sensitive. The non-offending parent, the guardian, legal representative, or appropriate child assistance authorities involved. A victim is entitled to access the mechanisms of justice without hindrance, and that we should at all times show empathy and sympathy and understand the situation rather than exacerbate it. The responsiveness of judicial system is critical to the needs of a victim. And the model law says that shall be facilitated by the following. One, informing the victim of the role, scope, timing, and progress of judicial proceedings, and how long it may take to dispense of the case, and to update at any critical stage what is pending, the timelines that the rules of the law imposes, allowing the views and concerns of victims to be presented and considered by the court at an appropriate stage, and providing all assistance that the victim may need, and taking measures to minimize inconvenience to the victim, protect the victim's privacy when necessary, ensure the victim's safety, as well as that of their families and witnesses from intimidation, re-victimization, and retaliation, and avoiding unnecessary delay in the disposition of cases. The gender model law also speaks about the cautionary warning or corroboration rule in gender-based violence. I do not know whether that rule still survives. I know that in many countries it has been declared unconstitutional or has been disregarded, where the old position used to be that the evidence of a victim of gender-based violence or of rape, the evidence is suspect, and because it is suspect, it must be corroborated in order for the court to believe it. I think in most countries that is now part of the dustbin. It belongs to the dustbin of history. Law enforcement officers are critical in processing these cases, not just the court, it's the whole chain. And they all need to be aligned and work together in order to deliver services, judicial services that are sensitive to the victim. And the organization, the judiciary, the magistrates, the court, whatever you may need to call it, must remain accountable in terms of the manner in which it treats these cases, in terms of the speed at which it proceeds. There cannot be continuous, endless postponements around issues like this. They're usually time sensitive. I want to stop here because magistrates may have some observations to make around these issues before I proceed next to talk about the victims' entitlements and access to legal services. I suspect some of you may want to chip in before I proceed. Any comments, observations?
There's a hand from Justice Rao Kabwani.
Yes, Justice.
That's the only hand I see for now.
Yes, Justice.
Okay.
Yes, Justice, you want to say something? No? No, she says no.
Okay, no, I have a comment. The model.
You look like my former students.
I am.
Yes.
I am your student. Thank you.
Please continue.
Okay. The model on the rights of the victims seems to be skewed or biased against men. It's more about, I see it as more about the protection of women and girls more than the opposite gender.
Yes.
For example, it will talk about a victim, but then again talk about women and girls. For example, if you look at the protection from gender-based violence at paragraph 3, it says women have a right to refuse sexual acts. And I'm asking, what if the victim is a man? And then if you go at paragraph 6, it says the government shall put in place policies. It says women and girls are accorded protection from gender-based violence. And I'm asking, shouldn't these policies also protect men where they are victims?
Yes.
There are so many examples that I can give. Yes.
Yes.
Thank you.
Yes, I think that is noted.
There's
we'll
another hand.
Yes, SG.
There's a hand from Justice Michelle April Benjamin, and on the chat, you could probably request Justice Humolemo Mushweu to expand on the contribution.
Yes. Go ahead, my lord.
I wish I was Justice. I'm not. It's Humolemo here from South Africa.
Yes, my lady.
Yeah. My question is, in a case where a magistrate himself or herself is a victim of GBV, how can such a magistrate ensure access to justice for victims that appear before him or her? Yeah, that's my question.
Very well. Very well. Thank you very much. Any other contribution?
Good day. Good day. Can I proceed?
Yes.
Thank you so much, Honorable Judge, and allow me to greet the justices and all the delegates. I just want to speak to the first part of your presentation. Apologies for not introducing myself. I am Michelle April Benjamin, and I am a magistrate in the family law, specifically Children's Court in South Africa. I just want to speak specifically when you mentioned in the first part, when you did your introductory statements, you spoke about the accountability of member states and also setting principles and measures in place in order to keep them accountable. And the specific question that I want to ask regarding that is that in some of the states also, as it came through from our presenter, Linda, certain, for instance, child marriages will be criminalized, and in another state, it is not, they're still working towards. And you would understand that people move from state to state within the SADC region. What has been done to expedite and to create the uniform approach when we look at the model law itself? Is there anything in place at this point where we can say that because of the urgency of gender-based violence, because of the urgency of this particular problem across the member states, that these are the measures that are in place to expedite and to make sure that there is uniformity when we look at gender-based violence. Thank you.
Thank you very much. I'm going to try to answer them. If there is anything from these questions that Mia or Linda would like to comment or answer, just note them, and when the plenary time comes, then speak to them. I'll attempt quickly the questions that have been asked, starting with whether the gender-based violence, the model law is biased against men. If you read it in totality, it tries to ascribe and to commit and to comply with the key principle that underpin it, which is that one of equality. The constant reference that you may find to women and girls speaks to the reality of the disproportionate impact that gender-based violence has on men and women. But the correct position, as you articulated, is that it cannot and it should not manifest inequality in any form around male and females. My good friend Homolemo asked a difficult question. I don't know what the answer is.
I'm happy to assist you there.
So Mia will help me with that one. Yes.
Shall I wait for plenary to do that?
Yes, let's wait for plenary because I see that time may not be. Just noted for plenary. And then the accountability of member states. Is there anything being done to expedite the creation of a uniform approach given the agency of GBV? I will direct an order that the SG will answer that question about whether there is anything being done, and Linda may assist. So in view of time, let me just finish off so that we have time for plenary to revisit the questions that have been asked and others. Now, on the issue of victims' entitlements and access to legal services, the modern law says a victim shall be entitled to the following rights: the right of a victim to reasonable, accurate, and timely notice of any judicial proceedings, parole proceedings. A victim has a right to be informed of his or her remedies and support services and on how to obtain them. The right to seek restitution from the offender, or the right to seek restitution from the government. I haven't seen much suits against the government around gender-based violence, and maybe we need to see more of these, but the lawyers are the ones who can make that possible, because the bench awaits only to be asked to adjudicate over disputes. The right to safety and privacy and to be free from hardship during investigation, prosecution, and hearing. Hearings not in open court. Where in gender-based violence proceedings before a judicial institution, the institutional body is satisfied that there are special circumstances that make it desirable in the interest of the proper administration of justice that the proceedings or any part of the proceedings be excluded from public hearing, that could be done. A judicial institution may order that a victim testifies away from the perpetrator in different rooms or by use of separating room. I think Justice Mia spoke about the spin-offs we got from COVID. that now we can have victims testifying away from the physical building called the court, where the perpetrator may be. And that does offer some safety to the victim. A court or a judicial institution may, without prejudice to any other powers, on application made by a victim, whether or not an application has been made by the victim for any other relief, grant an injunction or other order for the personal protection of the victim, restraining the perpetrator from entering or remaining in the premises. I think Justice Mia spoke about the problems about restraining the owners of property coming back to their home. And I think this gender-based, the model law speaks to those issues, that these are some of the orders that you may give: restraining a perpetrator from entering the place of work of the victim and obligating public official to duly enforce the protection order. And again, it says that a court, without prejudice to the power of a judicial institution to punish a person for contempt, the judicial institution may, if it is satisfied that a perpetrator has knowingly and without reasonable cause contravened or failed to comply with an injunction, order that the perpetrator pay a fine. I see there is an amount there, but I think it's of no consequence. What is of consequence is the principle: require that the perpetrator enters into recognizance with or without sureties. That is what may be done. And where a person applies to court relating to a case connecting or relating to gender-based violence for leave to intervene in the proceedings, and the court is satisfied that a person may be able to prove the facts relevant to the issue at hand, it may do so. An intervening order under this section may be made on conditions that the court may impose. And then there is the issue of restitution, that a perpetrator or third party who is responsible for the perpetrator's behavior shall, where appropriate, make restitution to the victim, which restitution shall include compensation in monetary form for the harm, injury, or loss suffered. And where public officials or other agents acting in official or quasi-official capacities have violated gender-based violence laws, a victim shall receive restitution from government or the perpetrator. That is how progressive the modern law is. And it says that where restitution is not fully available from a perpetrator or other sources, the government shall endeavor to provide financial assistance to a victim who has sustained significant bodily injury. Where restitution is not fully available from the perpetrator, the government may step in, especially in situations where there is significant bodily injury or impairment. And also issues around procedures, legal services to ensure access to justice. It says that a service provider shall ensure when attending a victim that they are non-judgmental, they are supportive, already spoken about that, proceed in a manner that considers and prevents secondary victimization. I think secondary victimization comes when, in terms of the service providers, they act in a manner that literally serves to continue the trauma or the injury or the pain. That must be avoided at all costs. And it says, and this we know to be quite common, it says this model law says mediation shall not be permitted in any case of gender-based violence before and during judicial or quasi-judicial proceedings. It prohibits mediation. And we know in many of our jurisdictions that women who report these issues, sometimes the police don't proceed any further because the complaints have been withdrawn. And he also says marriage shall not be a competent decision in cases of sexual assault or rape cases or due to the woman or girl being pregnant as a result of sexual assault. A judicial institution shall ensure timely and expeditious proceedings. We have spoken about that. And the rights of victims during judicial proceedings are also stated. A victim shall have the right to decide whether or not to appear in court or submit evidence by alternative means, including drafting a sworn statement or affidavit, requesting that the prosecutor present relevant information on her behalf, and when appearing in court, give evidence in a manner that does not require the complainant or victim to confront the defendant. Protection within the court buildings and in court, and to testify only to the extent necessary, to request closure of the courtroom during proceedings if that is constitutionally permissible, are some of the rights of the victims. There are many, actually. They run almost into 2 pages. And it also says criminal proceedings shall not be a bar to civil proceedings be initiated against the perpetrator or anyone who acted negligently. Evidence and evidentiary procedures. The model law says, for the purpose of a law on gender-based violence, a matter of fact shall be taken to be proved if it is established to the reasonable satisfaction of the judicial institution or quasi-judicial body. I'm sure many of you would like to speak to that one. It may have some issues that I just realized now. And where a provision of the law requires the judicial institution or body to be satisfied of the existence of any ground or fact or any other matter, it is sufficient if the judicial institution or body is reasonably satisfied of the existence of that ground. So all those rights are detailed extensively in the model law. And it says a prosecution of gender-based offense may proceed in the absence of a victim. So the prosecution of a perpetrator may proceed in the absence of a victim. In other words, the absence of a victim should not be a valid ground to postpone a matter. The legal system, prosecution, and sentencing policy with regard to gender-based violence are ensured. That is very important because we all know that at the end of the trial comes the most complicated or difficult thing to do, which is appropriate sentence. The model law says that we must ensure that the evidential rules are non-discriminatory. The cautionary warning or collaboration rule, I have already spoken about it, and that legal defenses such as provocation shall not be invoked to escape criminal responsibility. That is what the model law says. False accusations shall not be invoked in gender-based violence cases. Being under the influence of alcohol, drugs, or other substances, unless forced, shall not exempt a perpetrator from criminal responsibility. A marriage or other relationship shall not constitute a defense to a charge of sexual assault or rape. In other words, it makes a marital rape a criminal offense. And there are general requirements for the criminal justice system, prohibitions relating to gender-based violence, and the obligations it imposes on the minister. All forms of gender-based violence are prohibited. Now, there are certain factors that I will highlight before I conclude relating to the work of the magistrates and the judges, which is important. I hope to do so in 2 minutes. And this relates to factors when imposing imprisonment. It says that a judicial institution shall take into consideration the following factors when sentencing a perpetrator and shall impose an imprisonment term if these factors are present in offenses punishable by imprisonment. but with an option of a fine. The offense involves serious injury or death of the victim or another person, including death as a result of suicide. The offense involves a victim who is particularly vulnerable, including a pregnant woman. The victim was deprived of liberty. These are the factors that the court must take into account when passing an appropriate sentence. It says you shall take into account all these circumstances. The victim is physically and mentally handicapped. The victim is a child. You take that into account. The offense involves more than one victim. You take that into account in imprisoning the perpetrator. The crime was committed as part of the activity of organized crime, drugs. A child has been adopted for purposes of exploitation. The perpetrator is a state or public official.
Josh, you are muted.
And on general offenses, it says that a person, except a victim who is a woman or a child, refuses to answer. These are general offenses. Refuses to answer any questions asked for purpose of an investigation, or gives an answer which is false or misleading. Fails to produce a document required for purpose of investigation. This may constitute an offense. Refuses to allow an anti-gender-based violence monitoring officer, a child marriage prohibition officer, or willfully moves a victim out of jurisdiction or place of safety is one of the general offenses, or fails to comply with any order or warrant issued under the law. So that summarizes, that is the end of the substantive provisions relating to access to justice. So 1 minute on conclusion. I have given an overview. The modern law is very extensive. It may be useful to have a copy of the actual modern law because even in its state, even before it is domesticated, even before it is adopted, it makes reference to very important international legal instruments that are always useful or implicated when we deal with these issues, and you can refer to them. So to that extent, the modern law, even before adoption, even before domestication, is useful because it makes reference to sources of international law. And as we know, within the limits of our laws, there may be opportunities to use this international law.
Justice Dingake, you're muted.
Hello?
We can hear you now.
Yes, the host keeps on muting me, so I don't know how it says the host muted you earlier. Anyway, I've said we have spoken, all of us, you have spoken about gender-based violence as a human rights issue. And we have also spoken about the gaps that are there, the value of the SADC model law that once adopted can act as a very important resource, and that this model law complies with international human rights law and regional instruments. It will not be binding, but it should be persuasive, and each state is free to pick and choose which aspects of the model law going forward they would wish to domesticate. Thank you very much. That ends my submission. I now open the floor for the plenary that you can engage with some of the issues that the previous speakers have spoken about. But before we do so, I'll allow Justice Mia and Linda for the questions that were you may have wanted to answer, to do so now before we go into the next round of engagements. Any one of you can go first.
Linda, do you want to go first or shall I?
Shanaz, I think perhaps maybe I'm going to actually allow my question to be directed to Madam SG, because I think it pertains to the vision of how she would see the model law ultimately rolled out and implemented. And obviously it's a model law that provides guidance and standards, but obviously it doesn't dictate to any of the member states. So although there would be a vision for harmonization, it's not something that could be measured and controlled. So that's my submission. Over to you, Shanaz.
Thank you, Linda. Dr. Mashu. In response to your question, how does a magistrate who is experiencing gender violence preside over gender violence matters? One would ask the question, how does a magistrate who experiences a robbery deal with robbery matters? What often happens is the presiding officer is taken out of that court for a period of time and then placed back in court. Now, it depends on the management issue. But another factor that needs to be taken into account is what extent of sensitivity, or to what extent has there been, I think in the past we called it gender-based gender inequality and sensitivity training. To what extent have we trained our magistrates to be sensitive and to be aware of the biases and aware of the filters that they come in with? To what extent is that particular magistrate traumatized? And if that particular magistrate is so traumatized by the own violence that they're experiencing themselves, clearly that is not the person that you want to put in that particular court. So it is clearly a management ensure that somebody experiencing that kind of trauma is getting the necessary support from a mental health professional and any other support that they require. But in the workplace, from a work perspective, if they're coming to work, if they're fit to come to work, it is that senior magistrate and the chief magistrate's decision as to where the person is going to be suitably placed and whether the person is in a position to deal with those matters. And that is where the issue comes in. Is such a person in a position to make such decisions? Because you are colored by your own experience in such instances. And you need to work through those experiences through your own experiences with a health professional and to get the necessary support before you are able to deal with similar matters adequately. So in the short term, possibly not. But in the long term, once there's been appropriate support and debriefing, there's no reason why that person would not be in a position to deal with those matters. If that were the case, then our magistrates would not be able to be dealing with theft, with robberies, because many of us have had those experiences. And I trust that I've asked that question. If there's any follow-up to that or any response there too, I'm happy to, Dr. Michaud.
Yeah, Judge Mia, I think in the case of domestic violence, it's a kind of a personal matter. Some people treat that as a secret. They wouldn't tell at work that, by the way, I'm going through this particular challenge at my house. And I guess that is where the problem comes in. And if you there are instances of, the latest one was in KZN, that politicians always hammer Sajay about magistrates who gave a really shocking outcome of the case and the way he or she treated the victim in court. So sometimes one asks herself that such a magistrate, is she or he not also in their personal space going through these challenges, and how do we deal with it? To encourage the magistrates to be open about it, so that what you say, that the management could be able to come with some kind of intervention. But the challenge is when they deal with those issues as being their issues, and they're not open to share with others. Thank you.
The challenge
I also,
yeah, sorry.
Yes, Mia, go ahead.
I think the challenge is that we need to stop making this violence such a secret, and that we need to be able to bring it out into the open, and to have courage to have these frank discussions about it in order to address it. Whilst it remains hidden in the cupboard, we're never going to be able to address it. And that is the challenge that we face. And it means that we need to have frank discussions. And that possibly goes to wellness discussions, and bringing in professionals that will speak to these topics and invite magistrates to call in or make contact with the appropriate professional. I think the UN ODC just sent out a survey 3 days ago to check on judicial wellness. And this was one of the issues. It was wellness during the COVID period, but we know that during this COVID period, instances of gender-based violence increased, as reported by magistrates. So if it increased for the general population and magistrates form part of that population, would they not be affected thereby? Is it too simplistic an analogy to make, or is it realistic?
Thank you. Thank you very much for the answer. I think one possible. Can you hear me?
Yes, we can hear you, Justice.
Yes, I was going to say to Homolemo that one possible, it's a complicated one in some way, But one possible answer is that as judicial officers, all of us within the judiciary, judges, magistrates, when we preside on any issue, we need to connect and engage with ourselves, our conscience, with respect to whether are we capable of being impartial. Now, that question, whether are we capable of being impartial, it requires sincerity and honesty from a judicial officer, since these are the values that we expect judicial officers to have, to say, given this that happened to me, or given the way I feel now as a result of this particular occurrence, I do not think that I can do justice to this matter. I can be impartial. And if a judicial officer comes to that conclusion, that given what he or she knows to have taken place, that may have been adverse, he or she can't bring a fair mind to bear on the dispute, then such a judicial officer ought not to preside. I can tell you it's never an easy question when you confront yourself in that manner. But it's one of the ways of proceeding. If we had time, I'll give countless examples that I experience around some of the issues of recusing yourself, but we don't have time. But I think the underlying principle is that each and every judicial officer must be honest and say, can I preside? Can I render justice fairly and impartially, given these circumstances? And if the answer is that my question doesn't allow me to, I can't be impartial, then the officer should not preside. That would be my take on that one. Any other comments?
Justice Mwenga Sima.
Justice Mwenga.
Good afternoon, and thank you for the opportunity. I do observe all protocol. I have listened carefully, and I'm so grateful for the presentations and the responses given so far. Just an observation, and I hope it's not too late.
Yes.
Just an observation. I have noted that from the presentations, gender-based violence has been viewed from both the civil perspective and the criminal perspective, and I'm sure rightly so. But I note that there is one aspect that, unless I've missed it, the model law does not contain. The aspect is that of violence, especially affecting women and children, where in particular there is a death of the spouse who has died intestate. Speaking for what happens in Zambia under our Intestate Succession Act, when one dies intestate, a personal representative, we call administrator or administratrix, comes in. But that will be a person with interest in the estate. Oftentimes, you find that there are young children involved in there who are beneficiaries, and the people that come in to be administrators and letters have been are granted to them, we do not have a mechanism to follow up how the administration has been done. Do we have a provision in the model law? And if not, can that be considered? Because I consider that to be violence against the victims vis-a-vis property rights that they are legally entitled to. I submit and thank you very much.
Thank you very much. I've noted that. I've noted that observation. Of course, the model law is couched in the most elastic of terms. If you go through its language, it doesn't anticipate every specific situation that may arise, but you'd find in its provisions that it does contemplate and anticipate issues around violence arising out of all kinds of circumstances, social, political, economic, technological, and so forth. Those are encapsulated in different ways in different provisions, but not one that specifically addresses issues of intestate succession and the violence arising therefrom per se. Thank you very much. Any other further comment, observation?
We have two hands up, Judge.
Yes.
I don't know if they're old hands. From Justice Muinga.
Okay, I can see. Okay.
And Huaba.
Okay, Jackie hasn't spoken. Huaba will come. Alice will come after Wessels and Muinga.
There's another hand from Justice Prince Boniface Muinga.
Yes, let's start with Jackie, Wessels, and then Muinga, and then Alice.
Good afternoon, everybody. And I just want to thank the presenters for very interesting presentations and discussions so far. I'm the Regional Court President here in Limpopo in South Africa. With regard to the model law, I think it's an extremely important effort that has been taken by the SADC Parliament, and that it is important that it must be progressive and to give proper guidance to all of us in this regard, in this very serious aspect. Some mention was made by some of the presenters regarding cyber violence, and it might be necessary. You mentioned the issues with lawyers and interpretation. So it might be necessary to consider including in the definition of gender-based violence also the reference to online gender-based violence or cyber violence or gender-based violence, cyber crime. You know, those terms are being used interchangeably. And maybe even consider providing the definition. There's some general definitions of cyber violence available. I've been working both with cybercrime and gender-based violence. And when you're dealing with cybercrime, you know, everybody primarily think about the big cyber attacks, you know, on institutions, etc., and the ransomware and all of those kind of things. And they forgot about the fact that cyber violence is at increased and it is rampant. And it is really necessary that we give more attention to particularly your gender-based violence, cyber crimes or your cyber violence, in particular aspects such as your online child sexual exploitation, as well as all of the different forms of cyberbullying, including issues such as revenge porn. That has also been increasing a lot as people have been using more and more, you know, online applications, etc. One of the other things to consider probably as well from a gender-based violence perspective, internationally, there's been a lot of, and for quite a while now, the talk about the fact that, for example, the use of terminology such as child porn, which we still have in most of our legislation, is actually diminishing the seriousness of what we're really talking about, and that it should be rather referred to as child sexual exploitation material. And it might be something to consider, considering this is a model law, to also give some guidance in this regard. And that maybe some reference to that can be considered to be included as well.
Sorry, Jackie, I missed that one. You said reference to what?
Child sexual exploitation material instead of the use of child pornography, because that is actually what it's really all about. It's
Thank you. Yeah.
sexual exploitation material. Yeah. I'm very glad to see that there was reference to audiovisual link under the procedure, the ways that witnesses can testify. But again, from an interpretation perspective, how lawyers are, maybe the words remote audiovisual link should be added, or remote, because we really need to consider, in particular for the safety of the victims, and also to prevent, the secondary traumatization, as well as the victimization they often get in court, or just outside of the courtroom with the family and the friends and of the victims. We saw that very often happening. That we made clear that this can be that they can testify from somewhere else outside of the court building. But that also, you were talking about that mediation should not happen, which I absolutely feel is extremely important that it be in there, but maybe also that there be some consideration of inclusion, something about the fact that it possibly should be an offense to coerce victims in withdrawing or not proceeding with the cases. How that happens, that the family and the friends will coerce the victim, don't proceed, because then who will look after us? You have to withdraw the case. There's nobody else that, bring in the money. That kind of thing happen a lot, or this intimidation that is happening with the witnesses, which also, in our legislation, we've got the legal duty to report if you've got reasonable knowledge or suspicion, especially where it's children or those with mental disabilities. And to break the silence, because often that's part of the problem, is people know that something is wrong, but they won't report it. Maybe for fear of reprisal, etc., or they prefer, I don't want to get involved. Maybe considering, I know that sometimes people regard it as controversial, but should there not be at least some legal duty on not necessarily everybody, but at least, certain professions, etc., that there must be a legal duty to report knowledge or suspicion at least. There's one other aspect that, when you were talking about sentencing issues, the importance of the impact of this crime on the victim, the family, and the need for the victim to be allowed to have his or her voice heard. That there should be a consideration of victim impact statements, or reports on the impact of this crime on the victim. And as it was indicated as well, often the children, that is the indirect victims in gender-based violence, especially within the home. One other aspect that I'm been involved in one of the other UNODC projects as well, where we were looking at women in conflict with the law, where you often would find that they're in conflict with the law, but they themselves are within an abusive relationship, that they kind of coerced or forced into a situation where they then ended up being in conflict with the law. And that those are the kind of issues that maybe also need to be considered, that even where it is an offender, that there could have been, or very often is, a gender-based violence element that lead to this conduct. and that is something that also need to be considered when we are looking at it from a sentencing perspective as well. Just coming back to what you mentioned earlier about the extraterritorial jurisdiction, that is extremely important, in particular where you're looking at the cyber violence aspects, because of the fact that this is such, it hasn't got any borders. There's no borders to these kind of crimes, also with trafficking and some of the other gender-based violence practices or crimes that we're talking about. And it is important, between the SADC countries, there is the mutual legal assistance agreements and protocols in place, but they don't necessarily refer specifically to gender-based violence related matters. So maybe that would also be something to consider or look into from that perspective. Thank you. I think I said a mouthful. Thank you.
Thank you, Asas. You said a mouthful, all very useful, I think. We have noted everything that you have said. Thank you so much. I see there are quite a number of hands. People want to say something. Let me just say that the Secretary General has asked to be excused. She has some urgent business to attend to, and I just wanted to say that Secretary General, leave is granted. Thank you for your presence and contributions.
Thank you very much, Judge. Maybe if you allow me, there was a question asked as to whether member states are doing something about GBV. Just to indicate that indeed there's a lot happening in whatever shape or form, but what the model law underlines is that for effective and efficacious handling of cases, we require very strong and robust legislative and institutional frameworks. When we started the model law development process, we did a huge study, and I've put the study in the chat group. It can also be shared with you if you request. And it became very clear that there's a lot of work happening in member states. However, there are loopholes where that do not allow us to be able to do or eradicate or stem out the issue of gender-based violence. And therefore, it follows that that is why we have issues around access and provision to justice, among others. So the PowerPoint presentation also will be shared with you if you so wish, so that you can look at the comprehensiveness of this study. There were texts that were shown in every component that we felt will be useful if we are really quite, serious or would like to be coordinated in the manner in which we're going to address the issue of gender-based violence. I thank you, Judge, and thank you for your attendance.
Thank you very much. Thank you, SG. Much appreciated. The next speaker, I'll call upon Chipalo, followed by Alice and Mwinga. In that order, Chipalo, Alice, and Mwinga.
Thank you so much, Director of Program. Good afternoon to the justices. May I just say all protocols observed. I followed the proceedings, and my understanding is that the model law is centered on the upholding of human rights. Now, given this scenario of criminal proceedings, where constitutionally a perpetrator or an accused is innocent until proved guilty or until himself admits the charge or charges. Now, without prejudice to the victim's welfare, who, from what has been presented, is, for lack of a better term, is being given preferential treatment, where she can even testify in a separate room away from an accused person or a perpetrator. Now, sitting as a magistrate who is supposed to be impartial, how do I balance the scales, given that even the perpetrator has the right to a fair and free trial? So how do I balance the scales so that it is not seen that my proceedings or the proceedings before me are biased towards the accused person and biased against the accused person or perpetrator and biased towards the victim? So how do I balance the scales? Thank you.
Well, noted. Thank you very much. I had mentioned the order, so go next, the one that I mentioned. I forgot who I said. Is that Alice?
Yes, Alice, thank you very much once again. Good afternoon. My contribution is this. I run a GBV court, and the court experiences a lot of applications for withdrawals by victims, mostly because of for economic reasons. You find that the perpetrator is the provider at home. I was thinking, and it's my recommendation, that this model should provide for rules or regulations for withdrawals to guide courts when such applications are made. I'm speaking from my jurisdiction here in Botswana, where we don't really have those laws. You find that an application comes and it's really in the hands of a particular magistrate whether to withdraw the case or not. So the model will really help states that or nationals that do not have such laws. The second contribution is I would love this model in access to justice, digitization of the courts in order to improve access to justice, and also to allow for reporting by any person who is himself or herself, who is not himself or herself a victim. Because like we said, these victims are vulnerable and they may not report for fear or for other reasons. I think that's all.
Thank you very much.
Yes.
Thank you. Now, I think it's noted the observations you made about the application for withdrawal for economic reasons and the need for some supporting legislation or regulations to guide the courts in those circumstances. And the last point you made about other persons being able to report GBV. I would like the next speaker, Chipalo has spoken, has he?
Thank you very much. Good afternoon,
Have you spoken?
everyone.
Are you the, did you speak earlier? No?
No, I didn't speak earlier.
Okay.
I just have similar names with the other speaker.
Oh, okay. I was confused. Go ahead.
Yes, good afternoon, everyone. My name is Mwenga Simanya. I'm a magistrate from Zambia. Judge, I heard during your presentation, you spoke about court proceeding in the absence of the accused person. My question was, is this fair on the accused person since he has a right to a free trial and he has the right to be heard? These rights are enshrined in the Universal Declaration of Human Rights, and I believe in many of the constitutions of SADC member states. So my question was, is this provision in accordance or compliance with already set universal protection of human rights. Because in as much as we are trying to protect the rights of the victims of GBV, the scales of justice should balance, in my opinion. My second contribution was on the laws on femicide. In our country, it is a defense for a husband who has killed his wife if he found her red-handed committing adultery. In my view, this just encourages femicide, and I believe that there should be laws that are included in the model law that restrict or take away this defense in a similar fashion that you removed the laws on corroboration of evidence regards evidence being given by victims of sexual violence. My third contribution was with regards to the earlier presentations that were given. I wanted to find out whether the SADC Parliamentary Forum has any deliberate policy or plan to financially support member states in sensitization of women and girls in the rural areas on their rights with regards to GBV. I also wanted to find out whether the SADC Forum has a deliberate policy to assist member states in setting up the one-stop centers. I read in one of the presentations that was forwarded, and I can actually agree that in most member states, very few places you are even able to count, maybe one in a province or two in a province, depending on which area they are in, have one-stop centers. And it goes without saying that these centers are very vital because they are able to not only examine the victims of sexual violence, but also render counseling.
Thank you. Thank you very
much. I also
much.
wanted to find out whether the forum has any deliberate policy in the future to carry out trainings for member states.
I can start
in terms
from
of the key members of the justice system. For instance, like today, we have a forum of magistrates. Do you have any deliberate policy where you are going to carry out trainings in the member states to train your magistrates, or is it police officers and all the different layers in the justice system? I believe this will be vital in the enforcement of the model law. Thank you very much. That was my submission.
Thank you so much. I'll call on Victoria. I think in view of the time, Victoria, you may be the last speaker, and then I'll ask for comments from the other speakers, and I'll come last on some issues that have been raised. Victoria, you'll be the last speaker in view of the time now, and then I'll get back. I see our numbers are slowly dwindling. So Victoria, please go ahead.
Thank you. Thank you very much. You can hear me?
Yes.
Yeah, I'm speaking from Tanzania. I'm a resident magistrate. First of all, I would like to thank all the presenters for health and full of authorities presentation. We have learned a lot. I will go straight to what a contribution from member states like Tanzania, what we are doing on that. As is spoken by others, that these instruments are just persuasive in our jurisdiction also, but most of the instruments have been domesticated in our laws, and we actually observe them. We have now construction of IJCs, integration justice centers, where issues of gender-based violence victims, including all vulnerable groups, including these, are cared. Also, we have some guidelines. Guidelines helps us in challenges we face when handling cases that sometimes involves gender-based violence victims. Like we have a guideline on effective administration of cases relating to vulnerable groups, including gender-based violence victims, and even the sentencing guideline gives some, when it's sentencing an accused person, it gives some levels of punishment that issues arising from gender-based violence have been given a high level in sentencing. When you are arranging the sentences, it is in the high level. Sometimes we magistrates faces some issues, like when you receive a charge sheet, you just find a charge sheet, it does not contain more, or the particulars, if they are not satisfactory, we won't realize if it's a gender-based violence case until you start the hearing. So sometimes we find that the laws governing preparation of these charge sheets should accommodate more details, so that you get to know that beforehand that this case relates to gender-based violence. However, mostly in our country nowadays, when the case comes, court has to come when the investigation is complete. So you may find some facts and read. So sometimes we urge as magistrates, when we are being trained or sensitized on these issues of gender-based violence, to read the case file properly and find out that now you are facing a case where inside it there is some elements of gender-based violence. Another issue that I find it for the organization to look up into is the safe zones for those victims. Let's say a gender-based case, a husband is the culprit and the victim is a woman maybe, and she goes back. Maybe the case is bailable, they go back home together. Nowhere to take the victim. So safe shelters, I think the organization has to look up into, all member states has to do something on those schemes for those gender-based victims. Thank you. That is my contribution.
Thank you very much, Victoria, and thank you everybody. We are going to try to address some questions. I'll come last. I know the Secretary General is gone. I don't know whether Kurasha is there to answer questions around SADC PF plans, deliberate policy. One-stop center has been raised to sensitize communities. Is Kurasha available?
Judge, good afternoon.
Good afternoon, Kurasha. You want to attempt those questions around your plans around sensitization, communities, one-stop center, training, all those issues. Do you have anything to say?
Thank you, Judge. What I could speak on is the context in which SADC PF operates, which is the fact that we work with and through national parliaments. So in the context of what we could do at SADC PF must be understood in that regard. So when a model law has been adopted, what follows is the domestication. And as you know, the domestication happens at national level. SADC PF works with national parliaments to facilitate and to be available where facilitation might be needed when there is engagement through parliaments with stakeholders to facilitate domestication, the domestication process. It has happened that sometimes SADC Parliamentary Forum has been invited through national parliaments to engage stakeholders further on the process, in the process of domestication, but national parliaments must take a lead in this regard. And we also at national parliaments, because each member state is represented at SADC PF by delegations or delegates that are drawn from parliaments, which is the speaker plus 5 other members. Those are the primary vehicles through which we push for the process of domestication at national level. On its part, SADC PF, whenever we have developed the model law, and this will apply for this current one, is we will then follow up with a framework to facilitate the domestication one of which we develop a user guide for different stakeholders to be able to figure out what their role could be in the domestication process. And we also develop scorecards to facilitate the implementation process at national level. That is the extent to which SADC-PF's role could be or should be understood, Judge. We work with and through national parliaments, and therefore, if there are any requests, specific requests that could come, they could come to SADC-PF, but they could also be channeled through national parliaments, who are the constituent element of SADC Parliamentary Forum at the regional level. Thank you, Justice.
Thank you so much. I appreciate that. I hope it is helpful. I'm going to call upon, in view of the time, and I see people are leaving the platform one by one. Mia or Linda, anything you picked from the questions you wish to answer briefly, so that we go to the closing remarks and we are within time?
Thank you, Judge. It's Linda. I'd like to comment on the issue of capacity building. And I would like to point out to the participants and honorable magistrates that UNODC has a variety of resources to build the capacity of criminal justice practitioners on gender-based violence. So I would urge you to actually look at the website that we have, and look at the possibilities of sharing those resources with members within the criminal justice sector. And Yaki has also provided a resource that we recently developed on a handbook for the judiciary. Over and above that, there are plans in the pipeline to actually look at a series of webinars for criminal justice practitioners during 2022 with the SADC Secretariat. With regards to the model law, I know that in 2022, we also, with the SADC-PF, looking at building awareness on this particular process to build sensitization and urge member states to look at how they can actually draw on the standards of the model law and build on their legislative processes. That's my submission. Thank you, Judge. Over to you.
Thank you very much. Mia, you have anything to say?
I think we just missed a question from Mr. Baloyi in the chat. He spoke about the issue of the striking off the roll of gender-based violence cases. I think that falls squarely, and he spoke about judicial overreach. I don't think it's a question of judicial overreach in that instance. I think that is exactly where your judicial function plays out, that those matters ought not to be struck off the roll, and it is judicial officers who are striking those matters off the roll. So you need to exercise care when those matters are struck off the roll. And I know that the Judge President in Gauteng asks for a list of those matters that are struck off the roll and the reasons and how long those matters have been on the roll. And he checks to see whether the presiding officers have conducted the 342A inquiry before the matter has been struck off the roll, because of the concern that matters are being struck off the roll without reason, or without a proper inquiry being conducted, rather. Let me correct myself. So there isn't a concern. Once you've conducted the inquiry and you've exercised your discretion, there shouldn't be a problem. But before doing that, it would be appropriate to subpoena the investigation officer to explain why the investigation is not complete, and to hold the senior accountable, and to ask for reasons why the investigation is not complete. That addresses that question. There was a question with regard to the balancing of the scales. Now, it makes provision for the trial to proceed in the absence of the victim. That does not necessarily detract from the rights of the accused. What I had envisaged there, although that needs serious consideration, is that the evidence would be presented by way of affidavit or by way of pre-taped oral testimony. And that pre-taped oral testimony would have to be confirmed via a commissioner of oaths who is present when the oral testimony is presented. So the position would be that if the affidavit or the oral testimony is challenged, then that accused has the right to cross-examine the victim. And that is where you would ensure that the accused's right to a fair trial is guaranteed by allowing the perpetrator to exercise that right to cross-examine the victim to test that evidence. And that can still be done via an audio-visual link that can be set up at a later stage, and it can be done by an intermediary. In South Africa, the Domestic Violence Act makes provision for the questions to be directed through the presiding officer to the victim, so that there is no intimidation that the victim feels. And similarly, that can be done in that fashion. So I don't see that the right of the perpetrator to a fair trial is being infringed in that fashion. If the perpetrator is being afforded the right to present their case, to cross-examine, and to present their version. The only challenge is if the victim wants to consider or wants to challenge the perpetrator's version, they would have to be present in court, or their legal representative would have to be present in court in order to challenge whatever version is presented. I think that covers.
Thank you.
I'm covered.
Thank you so much. Thank you so much, everybody. I was going to, the last questions that I was going to attempt to respond to, I think Justice Mia has done so ably. I would only wish to add the following, to say that all the issues that were referred to by colleagues from the magisterial bench around the need to ensure that fair trial are observed and that the scales must remain at all times firmly evenly balanced are critical. But as you will know, every case turns on its own circumstances. There may be a case where the absence of a victim in a trial may occasion injustice or violate fair trial provisions. If it is such a case, then obviously that would be untenable. And there may be a situation where if you have a victim maybe being put in a different place for safety, if there are substantial and good grounds to say that it offends against constitutionally entrenched fair trial provisions, we know that those fair trial provisions in the Constitution must take effect. So it's a question of balancing at every situation. But what the SADC gender model law tries to do is to ensure that the structural and ingrained prejudices and biases that actually tilt the scales against women are avoided. It is not in all situations where you may need the victim to be physically present. It all depends on the circumstances of each case and the facts in contention or in contestation. So, but I think you are all right in saying that the scales, as a matter of principle, must remain firmly balanced. Thank you so much. Our time is not in our favor. We have had a very enriching debate and discussion. And I want to thank each and every one of you who have spoken. And I've been advised that the material, both the SADC gender model law, the PowerPoints, and other allied documentation would be made accessible to the participants. So thank you very, very much, everyone. We are running short of time. If you permit me, I now want to go towards the closing session of this very fruitful engagement. The concluding and solidarity remarks will be made by Marco Texera. I apologize for the pronunciation. She's officer in charge for the UNODC Southern Africa. Permit me, please, to call you to the virtual podium for you to make your concluding and solidarity remarks. Marco Texera.
Thank you. Good afternoon. And of course, Your Excellencies, Honorable Magistrates, Madam Secretary General of SADC Parliamentary Forum, Program Director, distinguished ladies and gentlemen, it gives me a great pleasure to be here today to conclude these very interesting discussions that I had the opportunity to accompany the last minutes in what regards the SADC model law on gender-based violence. I'm sure that your participation, your contributions during the proceedings are and will be able to allow us together to densify the model law, which in our opinion will be of instrumental value on providing solid foundations and references to magistrates in their adjudications of SGV cases in the region. Your subsequent approval and consolidation of the model law on gender-based violence is noted and very appreciated. It's also the guiding and driving force for us to continue this work together with you. Ladies and gentlemen, we are all aware that violence against women is a global program and has devastating effects on individuals, on families, on societies, and also to the criminal justice system. Indeed, it is an obstacle, in our opinion, to achieve the Sustainable Development Goals and the targets associated with the Goal 16 on rule of law, and also in the Goal 5 on gender. And for us, it's obviously an important element to continue to fulfill our obligation to protect human rights. Stronger efforts need to continue to be taken to protect women and girls and stop violence against them. Never is too late to change those practices. Even when laws and policies are in place, we have the common responsibility, the authorities have a common responsibility also, and you as magistrates to need to improve, to better coordinate and continue to be active drivers of change. Ladies and gentlemen, legislation is obviously, in our opinion, one of the ways that the states can guarantee human rights. And in that sense, model law and model laws, this need to be owned, as I have heard today, and also be seen as a living document that can also contribute and benefit the people of the different societies.
I've learned one thing on how to secure yourselves.
To advocate, and it's our role to advocate, obviously, a solid approach against gender-based violence, and allow me to make a few practical, I would say, propositions and proposals. First, I think we need to ensure that we continue to have a gender-responsive and gender-sensitive approach in implementing all the parts of adjudicating and actually addressing gender-based violence cases. In the second element, to ensure that we protect the dignity of victims above all and protect their right to privacy and to treat them with full respect. The third element I want to put on the table as a proposition is that measures need to be implemented to allow victims to be fully part of participating in the proceedings, to be able to testify without being traumatized and subsequently being victimized again. We need to ensure their voices are heard while we are considering the sentencing process. The fourth point I want to highlight is to understand the impact, and we need to make a strong effort to deconstruct stereotypes and gender stereotypes. And from our side, and I wish to reiterate our commitment as UNODC to continue to work with all of you, with magistrates in the SADC region, because we believe you are a driving force to the change that we all want to operate. In conclusion, I wish to thank the technical team for their diligent work in drafting the model law, to all of you for your valuable insights and discussions, and a special word, obviously, to my colleagues on UNODC and to my colleague Linda for always raising this as part of our flag, as part of our priority thematic areas to work with the SADC member states. I wish to thank also the SADC Parliamentary Forum for the strong partnership and leadership in this process. And finally, I want to wish you all of you a nice weekend, and for sure looking forward to continue these discussions and this area of work together with all of you. Thank you.
Thank you so much, Mr. Texera. Thank you so much for your very helpful commentary and incisive observations. I think we are in it together. It's actually everyone, UNDOC, SADC, and every one of us to join hands and to address this scourge. So I would want once again to thank each and every one of you. We didn't have enough time. The issues were interesting. And I think Linda today will go home very happy and vindicated that she really spent sleepless nights pushing that the magisterial bench must be consulted, and that since they are on the ground, so to speak, and that a number of these issues they have dealt with, not in theory, but in practice. I think today's session actually confirms that the magistracy is actually the coalface of the administration of justice, especially when it comes to issues of gender-based violence. So Linda, allow me to thank you for having made sure against all odds that this consultation takes place. Thank you very much for those tireless efforts. It is therefore my honor, I don't know whether Linda is there. It is now my honor and pleasure to close this meeting on that note. Thank you, everybody, and all the best. Thank you very much.
Thank you so much.
Thank you.
Thank you. Thank you, everyone. Thank you.
Thank you, Judge, for excellent moderation. Thank you.
Thank you so much.
Thank you so much.
Thank you. Continue doing the good work.
Thank you. Thank you so much.
Thank you.
Thank you so much. We are very thankful.
Thank you so much. Much appreciated.
Thank you
Thank
so
you,
much.
good
It was a
people.
good session.
Thank you. I learned a lot. I learned a lot from everyone. Thank you so much.
Thank you. We have learned a lot from you and other presenters.
Thank you. Much appreciated.
Thank you so much.
Thank you so
Thank
much.
you.
All. Thank you. Enjoy the
Thank
presentation.
you. All the best. Thank you, good people.
Thank you. Thank you so much.
Thank you. Much appreciated.
Thank you, Keith. See you. Bye, everybody.